The first category would be of prisoners who will serve up to 12 months. In those cases, prisoners will be automatically released on parole after having completed half of their sentence. In respect of the second band of prisoners will be sentences of over 12 months and up to 4 years. In those cases, prisoners will also be automatically released at the midway point of the sentence, but the parole board will be advising the minister on licence conditions. But then in respect of the third category of prisoners are those that have received sentences of over 4 years. In those cases, prisoners will not be automatically released on licence, but instead they will have to apply to the parole board, as is currently the case, and the parole board will have to decide whether that prisoner ought to be released on licence.
And Minister, not retrospective?
It is very important that the community does know that any changes to the Prison Act will be prospective. In other words, the Prison Act changes, once they're commenced, they will apply to persons who are sentenced from that date onwards. Prisoners who are currently in prison and those who are currently going through the criminal justice system will not be affected by the changes to the Prison Act, unless, of course, such a person going through the criminal justice system today is sentenced after the changes to the Prison Act come into force.
Well, another big change is that the system of remission will be replaced by a system of awarding of additional days. Who will actually determine this?
It will be decided by a justice of the peace.
And one thing that you state in your press release is that it's important to strike the right balance.
It is important to strike the right balance. As I've noted, the Law Commission has met on 5 occasions to determine the point at which a prisoner ought to be eligible for parole, and these were serious discussions because, of course, we are talking about the constitutional right of a person's liberty, even if that person has been sentenced under law and that liberty is being deprived. But the Law Commission, as is evidenced by the proposals made to government, have struck, we think, the right balance between deterrence for criminals to think twice before they commit crime, and also, of course, with assessing the risk of release to the community. The parole board is always very wary of whether a prisoner released is safe to be released back into the community, and of course the third objective, to ensure that the prisoner, once released on licence, is able to reintegrate successfully into the community.
Finally, Minister, what happens now? This is out for consultation. How much is set in stone? These are obviously recommendations to the government. Where does the last word lie?
Well, this, as you rightly say, a command paper has been published. The position of the government has been set out in that command paper, and as I said already, we accept lock, stock and barrel the Law Commission's recommendations. We very much eagerly await the input from the community. Once we receive that input, then of course we will have to consider the comments made, and the decision to proceed on the existing draft bill as it currently stands or revised will of course depend on the comments that we receive. So the last word has not been yet said on this. We are waiting for the input from the community, and at that point, once the bill is published, the community will be aware whether there have been any further changes on the back of that consultation or whether the bill published is exactly the same as the draft bill in the command paper issued today.